The first case this morning is State v. Robertson. Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. Counsel, how long would you like to reserve?
Your Honor, I'd like to have 5 minutes reserved for rebuttal.
Thank you. I will be keeping track of the time up here, so I will try to let you know when there's about a minute left of your initial time,
Okay, thank you.
so you can kind of wind down if necessary.
Thank you, Your Honor.
The arguments are being recorded. When you present your argument, please introduce yourself when you come to the podium, keep your voice up, and remain behind the podium at all times. It's also been visually recorded, and if you start to move, then we'll lose you on the visual recording. You should not use the name of any child, minor, or any victim. During your argument, you refer them by initials or terms like the child or the victim, whatever you feel is appropriate in this particular matter that you can use, and we can understand what you're referring to, who you're referring to. We've read your briefs and are ready to proceed whenever you are.
Good morning, Your Honors. Attorney Eric Hall, I'm here on behalf of the appellant Logan Robertson, Your Honor. Your Honors, this was a tragic case involving two young people. The victim, in this case, a young girl whose life was tragically taken, and the appellant, Mr. Robertson, who is essentially serving a life sentence now for murder. So it's a tragedy. My first assignment of error, Your Honors, is during the trial, the state committed prosecutorial misconduct, cross-examination of the appellant. What the prosecutor told the appellant, this wasn't a question. He directed the appellant, while the appellant was on the stand being cross-examined, to look into the courtroom and tell the victim's father, who was present in the courtroom, to tell the victim's father how his daughter died. This wasn't even a question, so it put the appellant in an untenable situation of answering something that's not a question. If he's silent, I mean, he's between a rock and a hard place. By answering the question, he puts himself in jeopardy to something that's not even a question. By answering the question, by not answering, the jury assumes that he's guilty because he won't admit or say what happened in the case on cross-examination to something that's not even a question, Your Honor.
I guess I've not had a chance to read the record yet, so this occurred during cross-examination.
During cross-examination, and it was objected to, Your Honor. But it was clearly prosecutorial misconduct. It was inflammatory.
Why is it misconduct if the father was in the room? He's saying, tell me how she died, that's the question, and father is in the room.
But Your Honor, it wasn't a question. It was directing the appellant to address somebody in the courtroom, who in this case was the victim's father, and to tell him, not the jury or the court, or answer a question placed them on cross-examination, but to direct your comment to somebody who's in the courtroom. That's why this was improper. It was clearly improper, and it crossed the bounds of proper cross-examination in this case, Your Honors.
Counsel, what was the ruling on the objection?
I believe that the objection was sustained, but that's not enough, because my opinion, Your Honors, once a jury hears something like this, you can sustain the objection, you can give a limiting instruction, but when they go back to the jury room, they're going to remember this. And this was so inflammatory. But there's more. This is not a case where there's just one error. Okay, if you take these things out of context, you can say, well, this was harmless error. The next assignment of error, okay, the court denied the appellant's motion to suppress. This is a case where his right to counsel was violated. Shortly after the grand jury in this case, the chief detective who was investigating this case, basically did what I would call an end run around defense counsel and visited with the appellant at the jail. Went to see him at the jail and talked to him, visited with him for 1.5 hours, knowing or having certain reason to know that he had defense counsel. Now the argument is that he waived his right to counsel and agreed to speak with this detective. This is a young man who's accused, he's been charged with murder. At the time this happened, he was under the influence of alcohol and marijuana. So knowingly, the argument is that he did not knowingly waive his right. He's unsophisticated. This is really the first time he's ever been in trouble in his life, and it's for murder, Your Honor. This clearly violated his Fifth and Sixth Amendment rights against self-incrimination. And I would argue that everything he told that detective, every question he answered, everything he said, was a statement against his interests. He should not have answered any questions, not a single question. Your Honor, I have people in the jail right now. Probably got a dozen clients, defendants in the jail right now. Who is to say that everyone, there's a detective talking to them right now, knowing full well they have counsel, these people are not sophisticated enough to know when to talk to someone and not to talk to someone. This was clearly improper, and the courts have suppressed that evidence.
This was a second interview, as I recall, from the initial interview.
It was.
And at the start of that second interview, was there any further discussion of Miranda rights at that point in time?
I don't believe so. If there was, Your Honor, he would not have understood it. And this was somebody, the appellant in this case, Your Honor, was a young man, okay? He had some problems growing up, okay? And he would not have been sophisticated enough to know that what these Fifth and Sixth Amendment rights actually would have entailed, unless he had counsel there to tell him, and that's what was missing in this case. His attorney, and this was a deliberate end run around his attorney to go try to get evidence to use against him in the trial. The third assignment of error, Your Honor, is the state introduced 404B character evidence. And the trial court allowed, over objection, evidence that a red or black car, and this is 8 months prior to this incident, 8 months prior, so there's no temporal proximity to the case at hand, that the appellant allegedly was driving, or in a car, red or black car, driving down the street of an individual who had been a friend of the victim in this case, and had fired a gun out the window. And the trial never identified the car was actually Mr. Robertson's car. Never identified him as being the person shooting outside the window. This was done when the state introduces evidence like this, 404B evidence, is to bolster weaknesses in their case. And they saw what they were concerned with in this case was a conviction for something less than murder. They were concerned about a reckless homicide or something. So basically, they wanted to paint the appellant as somebody who was a gun-toting criminal, a drive-by shooter, without any evidence whatsoever that was even him. This was clearly improper, and this was certainly something that should have been a mistrial, and it certainly is plain error in this case, okay? It should have never been introduced, and like I said, there's no temporal proximity to the case at hand, and he was never identified. That's the thing.
How is it not harmless error? When you have evidence that he had a loaded gun, that he admitted to shooting her, and that he changed his story also.
Right. But the loaded gun was a gun that he legally had, and they're saying he engaged in some kind of criminal offense, a drive-by shooting, which is a crime, a serious crime, without any evidence whatsoever. The underlying case was one that involved a firearm, involved murder. The defense is trying to show that this was an accidental shooting, and they're showing that, hey, he engaged, or allegedly engaged in some deliberate activity, firing a gun down a street, a suburban street, outside the window of a car. Clearly improper, clearly to paint him as a gun-toting criminal and somebody who engaged in drive-by shooting. My fourth and my fifth errors involve the sufficiency of the evidence, Your Honors. In this case, I believe the facts supported a conviction for reckless homicide, not murder. You know, the facts in this case, first of all, the gun, this was a gun that was loaded and it had no safety. So basically, it's a gun that if you pull the trigger or accidentally pull the trigger, it's going to go off. There are no safety mechanisms on the gun. Okay. Second, the appellant had consumed alcohol that day and had found later on that under the influence of cannabis and marijuana also. There was no evidence that there was any kind of plan or prior calculation that he intended to do this to commit a murder. The victim in this case had brought on food. They had planned on attending the prom together. When the gun was tested, both the appellant's DNA and the victim's DNA were found on the gun. I believe this is a case where it's simply a case of mishandling a firearm, whether that was just playing with the gun or during an argument and the gun went off. Okay, and it happens all the time. There was no evidence that they had made plans for the evening. I believe there was no evidence that there was any kind of an argument that took place that led to the shooting at that time on that day. So clearly, I think the jury lost its way. And the reason they lost their way, Your Honors, is because of the other evidence, the prosecutorial misconduct, the 404B evidence, and then this end run of the defense counsel where the appellant made all kinds of statements. Everything he said in that jail during that 1.5 hours
1 minute left, counsel.
was a statement against his interest charges. Thank you, I'll reserve my time for rebuttal.
Very good, thank you.
May it please the court, my name is Stephanie Zeranek, and I'm from the Medina County Prosecutor's Office representing the appellee of the state of Ohio. Logan Robertson assigns 5 assignments of error, all of which should be overruled. First, there was no prosecutorial misconduct during the trial. The test for prosecutorial misconduct is whether the conduct deprived the defendant of the fair trial, and the defendant must show that he would not have been convicted except for the prosecutor's conduct. The assistant prosecutor said to Robertson, "Look at AP's father and tell him how his daughter died." First of all, Robertson never answered that question. Secondly, he would not have incriminated himself by answering if AP had been playing with the gun and it went off, as he stated in other parts of his testimony. Even if there had been prosecutorial misconduct, Robertson would still have been convicted of murder because there was both sufficient evidence and the manifest weight of the evidence, finding in favor of that conviction. Therefore, he cannot show that he would not have been convicted except for the prosecutor's conduct. Second, the trial court was correct in denying Robertson's motion to suppress. He argues that all of the statements that he made to the detective on May 10th should be suppressed. However, he acknowledged at trial that he knew the detective believed him to be guilty of murder, but he talked to her anyway. He was not under the influence when speaking to the detective on May 10th, as he may have been when he was speaking to the detective initially on May 3rd. He had also had prior experience with being interviewed by the detective on the night of the murder. The detective read Robertson his Miranda rights, and he signed the form indicating that he understood his Miranda rights.
Well, what about the issue of the defendant objectively having appointed counsel?
Your Honor, there's a case from the Supreme Court of Ohio, State versus Murphy, that states that a Miranda waiver does not have to be explicitly made to be valid. So there was,
Well, are you waiving your Miranda right to have an attorney if you have an attorney?
I don't believe so, Your Honor. The case is that he did have an attorney, but he chose to spoke to the detective anyway. In fact, he even asked the detective, "What if my lawyer told me not to answer anything?" And the detective said, "I would consider the advice of your attorney." And yet he still talked to the detective.
Did the detective review the Miranda warnings with him the second time the detective was there to visit him at the jail?
Yes, she did, Your Honor. Third, the trial court did not err by allowing other acts evidence under Evidence Rule 404B to be admitted at trial. The Supreme Court of Ohio has created a 3-pronged test, which is consider whether the other act's evidence is relevant to making a fact more or less probable, consider whether the other act's evidence is presented for showing character or for showing a legitimate purpose, and consider whether the probative value of the other act's evidence is substantially outweighed by the danger of unfair prejudice. The other act's evidence regarding Robertson's behavior at AP's friend's house was correctly admitted. For starters, it shows motive and lack of accident on Robertson's part when murdering AP.
Was there an other acts hearing?
I don't believe that there was, Your Honor.
Because the rule requires notice and opportunity to be heard about other acts.
I believe that there was notice to the defense, but I'm not sure whether or not there was another acts hearing. Robertson testified to telling the detective that he had threatened AP's friend with a gun. And his behavior during the incident at the house, combined with testimony from other witnesses that Robertson had threatened AP with a gun before, made it less likely that his story that AP was playing with the gun when it went off was true. The other act's evidence also was essential to telling the story of AP's murder, since it showed how Robertson felt about somebody else having a relationship with AP. Fourth, there was sufficient evidence to sustain Robertson's conviction. He argues that the evidence presented at trial establishes reckless conduct, not purposeful conduct. However, a rational trier of fact could conclude, and did conclude, that Robertson purposely rather than recklessly caused AP's death. He was not intoxicated to the point of not being able to control his own actions, as the detective testified at trial. And there was the DNA of both AP and Robertson on the gun, but there was testimony that there was no evidence as to when that DNA had been deposited onto the gun. Multiple credible witnesses testified that they saw Robertson put a gun to AP's head several times, or that AP had told them that Robertson put a gun to her head several times. One of AP's friends testified that AP felt the only way out of the relationship was if Robertson killed her. Another friend testified that Robertson had sent a text message to AP saying that she was going to drive him to the point where he was going to kill her. Robertson also gave conflicting stories of how AP died, including that she was playing with the gun and did not believe him when he said it was loaded. However, there was testimony that AP was familiar with firearms and knew how to use them safely. Fifth of all, the manifest weight of the evidence is in favor of Robertson's conviction. He argues that the incident was a result of two young people under the influence of drugs and alcohol handling a gun. However, the toxicology screen performed on AP after her death did not show any alcohol in her system. He told the detective that he was under the influence of alcohol that night, and the detective was also able to observe his behavior. The detective testified that Robertson was not so under the influence as to be intoxicated to the point where he could not control his own behavior. Again, multiple credible witnesses testified that Robertson had threatened AP verbally, in text messages, and with the firearm on several occasions. The jury did not lose its way when convicting Robertson of murder. If there are no further questions,
I have one more.
please.
With regard to the interviews, my understanding from reading the briefs is that the defendant said originally that that she shot herself, then said they were playing with the gun, and then finally admitted to shooting her in an argument. Is that a correct?
No, Your Honor, he did have several different stories. He did say at one point that she had shot herself, or I believe he eventually settled on the story that he was trying to take the gun away from her because she didn't believe that it was loaded and it went off at that point.
So was there new information or a different story from the May 10th interrogation versus the first interrogation before the defendant had an attorney?
That's a good question, Your Honor. I'm not sure when exactly the stories that were changed were different.
Thank you.
Therefore, the state of Ohio would respectfully ask this court to affirm the judgment of the trial court. Thank you.
There's, talk about the misconduct again. The prosecutor directing him to address the father, the victim in the courtroom. There was no right answer to this. It wasn't a question. No right answer. The state has indicated that Mr. Roberts said different versions of what happened or different stories. And probably the truth of the matter is, because this happened so fast, he was under the influence of marijuana and alcohol, probably really doesn't know exactly how it did happen. All that we know that happened is that the victim in this case was killed by a handgun. Regarding the right to counsel, this is a young man. It's not somebody who's had a criminal history or background, who's sophisticated enough to know what to do and what not to do. Young, scared, inexperienced. It's a murder case too. This is a murder case. This isn't a fourth or fifth degree felony. It's a murder case. And he asked, the state indicated, he asked the detective basically what's a legal question. Well, what if my attorney told me I shouldn't talk to you? Well, the fact that the detective would be asked a question and even answer it shows again how his rights were violated. That's a legal question, and that should only be answered by his attorney and not by the detective, who once again did an end run in this case and ran to the jail right after grand jury to spend an hour and a half with him to basically try to get a confession. Everything he said was a statement against interest and should have been suppressed. The other act's evidence, Your Honor, I believe that notice was given. The state generally gives notice through discovery paper, written notice, but I don't believe that a hearing is held. I guess in retrospect, I think in every case when there's 404B evidence, there should be a hearing held before the trial to determine whether that's going to come in. That way, there's no issue of a jury hearing something that if they're not supposed to hear it, then they won't hear it. And I think that was done in this case. I think also the 404B evidence came in to show not only that he was a criminal, a drive-by shooter, somebody that would threaten people, but also that he was jealous, and he was jealous enough to kill. That was the point of bringing this in. But without any identification, That's what's so tragic about this. No identification. You know, if you could identify the person who did this, and it was him, okay, then certainly would come in. This is 8 months prior, they had no information other than just basically hearsay, speculation, no hard evidence that this was him. And then, you know, as far as the conflicting stories, once again, Your Honor, this happened so fast, okay, so quickly. You know, in a matter of a second, it takes the fire of a gun. And he really probably doesn't know exactly what happened, and he probably never will to this day know exactly what happened. All he knows is the gun went off, a tragedy happened, a young lady's dead. And, you know, that's why I think you have the several different stories, because it's probably not clear about your understanding. I would ask the courts, because of the number of errors in this, it's not just one error, it's several errors, okay, that violate his rights, allow things to come in that shouldn't have came in, and the court reverse this conviction. Thank you.
Thank you. The court will take the matter under advisement and issue a decision in due course. The clerk of court will mail a copy to each of you when that decision is released. The opinions are also posted on the Ohio Supreme Court website. On behalf of the court, I'd like to thank both of you today for your presentation.